You've nothing more to say, Mr. Crystal. Sorry, Mr. I saw you sitting down, so I thought you...
No, I do. There's just one piece of evidence, or two pieces of evidence I should have just mentioned. They're both to be found in Bundle 2. The first is and they are the two reports, the two scientific reports that were commissioned in April 2006, after the remedial works were completed. There's the report of Kaizen, K-A-I-Z-E-N, Mr. Balladin's evidence introduced and referred to that. They carried out soil tests around the site.
Which page?
The report begins at page 383. And they dug trial pits, and they were all chemically analysed. The location of the pits you'll see in page 395. So one was close to the well, but others were some distance away. And the conclusion was that there was no contamination and that the readings were minuscule. There was then air tests that were carried out by ROSE, or R-O-S-E, Environmental Limited. That evidence was presented by one of the authors, Dr. Persad. That is to be found from page 396. The places from where or the locations from where they did their testing is shown on the plan at page 401, which I showed you at the very beginning of my submissions. That was the plan that showed the wind direction, and the results are at page 402 in a table that shows, in fact, no traces of any kind of unwanted gas in the air. Finally, you see on page 402, the very last paragraph, VOC readings, so it's not confined to sulfur dioxide or hydrogen sulfide, were taken at the affected house, see well diagram, and were found to be 0. PB, that's 0. Thank you.
Thank you very much, Mr. Tager. Mr. Crystal? Yes, Mr. Benjamin.
My lords. Can I begin where my little friend left off and dive straight in, as it were, given that I have slightly less time than he does? Can I therefore invite you to just note a couple of things about the Kaizen reports and the Rose reports. These are reports that are produced in April of 2006 after the extensive remediation works were carried out. And I will take you to, very shortly, the evidence as to what happened, certainly to the evidence of Mr. Jurawan, which gives you an idea of the extent of the exercise, and therefore shows that the exercise was successful, extensive but successful. And it's no surprise that the readings, both for the presence of hydrocarbons in the soil as well as in the air, proved to be entirely negative, because that was exactly what Mr. Ryan had hoped Petroleum would do when he began to make his series of written complaints in February of 2006. In other words, I mean no more than that they would fix the problem. Of course, he wouldn't have the expertise or the wherewithal to say how they should do it. So by way of context, can I invite my lady and my lords? So I'm still on remediation. By way of context, can I invite my ladies and my lords to page 23. Hopefully that's the right numbering of the bundle.
Which bundle?
It's bundle 1, my lord.
Bundle 1.
Tab 2.
Certificate of Environmental
Indeed, my lady, yes. my lords have it? Deeply obliged. Can I ask you to pick it up on, so page 21, you will see the annex here, and the 22 and following. So a couple of things about it, my lady. First of all, it's dated the 2nd of March. I don't know if you can make out the date on page 22. That date appears just below the name of the executive chairman, Mr. Malcolm Jones. His signature is to the left of this very same page. And just above that is Ms. Coilas Abraham, who actually gave evidence in the case. If you could turn over if you go to the other page, page 23, you had asked a question, or my lords had asked a question about adjoining properties, and you'll see an answer there at number 7. Name and addresses of adjoining property owners, all adjoining properties owned by the appellant before you. And the real purpose for drawing this to your attention is to be found over the page on page 24. That's number 9. I invite your attention to the purpose. I've put in the bundle the relevant regulations, but I won't take you to it. But you will see under definition where this kind of activity, i.e. decommissioning activity, takes place. The law now requires an entity like Petroleum to seek a certificate of environmental clearance. The purpose is to complete the site decommissioning of one well site, FZ94, and its purpose, and I quote, to prevent further oil leaks in an effort to protect human health and the environment. So this is Petrotrin's document. It's Petrotrin's application to the relevant environmental authority, saying as of the 2nd of March 2006, the reason why we wish to undertake this expensive and complex, technically complex, exercise is for the purpose of preventing further oil leaks with the ultimate result of protecting human health. And if you look over the page at page 25, you will see that consistent with the, I suppose, the environmental standard, the contaminated soil and oily waste transported to its treatment facilities at Forest Reserve. The other thing that you will notice is that this application is made midstream, so to speak. You will know from the evidence that the process began on the 19th of February and went until about the 6th of March 2006. And therefore, Petrotrin got their tackle in order, although they did, albeit a little bit late. Interestingly, apart from the application to the Environmental Management Authority, can I invite your attention to pages 32 and 33? And you will see there, just to again give you context, this is the well abandonment program application. So this is the other state entity that's involved in the approval process. You would have heard bits and pieces of the evidence from time to time referring to the Ministry of Energy. And this gives some of the background to the nature of the well. And just one very small correction. If I can invite your attention to page 33, you will see at the end of the first full paragraph, there's a reference to, and I quote, a surface cement plug was also set from 28 feet to surface as a final abandonment procedure in 5/64. So to the extent that it's been suggested that there was a final abandonment in the 1940s, which is what is said in the previous sentence, I accept that, this is giving a more accurate and correct position.
So what, the abandonment,
So that this well, there was a suggestion from my little friend that the well that was originally drilled in 1927 was abandoned in the 1940s. I'm simply just correcting. It's purely chronological. I don't think anything turns on it, that in fact that took place in May of 1964. What occurs in the next paragraph is significant, and you probably read it already. The well is bubbling around the casing about 3 feet away and contaminates an area about 6 feet around the casing. Oil flows to a man-made pit about 15 feet away from where it is supposedly recovered by tanker. The pollution problem seems to be in existence for several years. The NWD, I don't know what that means, has already initiated construction of a containment tank to be installed around the casing, which serves as a temporary solution to the problem. A more permanent solution would be to drill out the present cement plugs, squeeze cement, the perforated intervals, spot new cement plugs, and officially abandon the well. So just again for chronological and historical context, you've simply got a well that was left in abeyance from the 60s, and here is Petrotrin saying to the Ministry of Energy, in Trinidad parlance, it's line ministry, the ministry to which it would be accountable, because of course, as my lords are probably aware, Petrotrin is a state enterprise.
So this is an application to the ministry to allow them to carry out the work.
Yes.
Is that right?
So this
What's the date of this document?
The best I can do...
On 34, is it the 2nd of...
I have not been able to discern a precise date, and the reason for that is that this document doesn't appear to have a signature. I think it was, well, it's self-evidently annexed to the CEC application. So maybe they just put another copy that was not signed. The best that I can do is invite your attention over the page. There's a receipt from the EMA, which is how Mr. Ryan obtained the certified copy. So, my Lord Ludka, sometime before the 2nd of March 2006 is the best that I can do.
But I mean, was this examined in evidence?
Oh, yes.
Yes, so I mean, presumably there's some evidence about when it was produced.
No evidence was for, but doing the best I can.
You will show us where it's dealt with in the...
Yes, absolutely.
But your point is that this describes a situation that needed remediation.
Yes, well, yes. So point number one, it needed remediation. Point number two, it's an admission by Petrotrin as to the purpose for which they were seeking to have this exercise undertaken. And they say to the state authorities, a contemporaneous document, why they're doing it. And they also are saying it to the authorities at a time when Mr. Ryan has already begun to agitate, if I can put it like that. So no litigation in prospect yet. That doesn't happen until June, July of 2006. And therefore, it can be given a certain amount of weight, having regard to...
It shows how it's dealt with in the evidence.
Yes. So I can say to you now, my lord, that it's not dealt with by any of the Petrotrin witnesses, i.e. I cross-examined on it, and I'm going to take you to that shortly, in terms of the contents of what...
Is it dealt with by the judge or the Court of Appeal?
No. Not in the sort of detail that I'm going to invite my lord's attention to. That is to say, of course, both the judge and Justice of Appeal Smith in the Court of Appeal refer to the fact of the mediation exercise. They do that, but not for the purpose that I'm going to take you to it for. Okay. My lords, can I just say to you, so that you have it, this was a document that was specifically pleaded and relied upon by Mr. Ryan. So it was drawn to their attention. I can make good that suggestion by just inviting you to go back.
But was this before the bubble test, or because we got a lot of evidence about the bubble
Absolutely, my lord.
test? Yes.
Well, no. So let me stand corrected. The application was not before the bubble test. There were four.
The bubble test was going to happen. Right?
Yes. So that.
By definition, the bubble test took place after the work was done.
Well, my lords, remember I began by saying that this document was sent in midstream. Yeah. So that, and you probably know from the evidence that there were at least 1, 2, 3, 4 bubble tests that were carried out. So they were carried out over different days, and I'm going to take you to that.
But it's a test, isn't it, of your new plug?
Yes, that was all afterwards, yes. Yeah, of course.
My lord, yes and no. So that at the end of the process, and if I could just kind of talk about that in very general terms, so that the purpose of the bubble test, of course, is to determine whether there is an emission of gas. So that at every stage, or at various stages, to be more accurate, the bubble test was deployed to determine whether there was gas escaping from the well bore. In the final analysis, there was as it were, a completion sign-off test done to satisfy the Ministry of Energy in order for them to issue their certificate of abandonment.
I think my question was on a false basis, so don't take up time. The bubble test here clearly came after the works, and it's not relevant to the point you're making about the first paragraph.
Well, my lord, I'm not as confident as my lord is that it came after. I think it actually both, before and afterwards. But I will take you to the evidence in a moment about what the well program was. Can I sensibly then, in order to answer my Lord's question, invite your attention to the evidence of Mr. Archie. His witness statement, as you know, is to be found at 624 to 641. It's tab 24, volume 3. 624. Well, that's the preliminary page. 626, in fact.
He's the geologist, yes?
My lady, yes, he is the geologist. I think you've only got one reference to his witness statement so far, but can I ask you to pick it up at page 628? And what you're going to see there in the narrative, starting at paragraph 9 and 10 and so on following, is a series of references to reservoirs. So at paragraph 9, Mr. Archie is giving an explanation. At paragraph 10, he's setting out the geology of Trinidad and Tobago. In paragraph 11, he's identifying at what depth do producing reservoirs occur in the southern basin, which is where Hicklin Village is. It's located in the south of Trinidad. He's vouching at paragraph 11 his access to the information and so on. Now, I'm not going to trouble you with paragraph 13, because if you look at it, you'll see why. But what I will ask you to do is to turn to the first of the exhibits, which is CA1. And again, I'm just providing some further context before I take you to the actual program, at least an attempt to decipher it. CA1 consists of the well log as originally drilled. And so what this does, it gives you a geological picture. And it tells you where, with respect, commercial quantities of oil and gas were to be located. And those have already been described by Mr. Archie as reservoirs. And the referencing in the right-hand column under remarks is to be, the key is gas show or slight gas show or good gas show. And my lords and my lady would have picked it up already. If you go to 633 for the first instance, you will see at the depth of, so I'm under the heading strata, is my lady with me? 150 to 200, slight gas show. And so what I did, just by way of context, I took Mr. Archie through this document so that he could identify to his lordship, at first instance, where the reservoirs were. And so what I'd like to do is simply just tell you where they are located.
So is this reference to July at the top, Mr. Benjamin?
July, my lord.
On the top left-hand box, date July.
Well, my lord, so the drilling is, so this is July 1927, my lord, just so that you have context. This is nothing.
This is when they dug the well.
This is when they dug the well.
Right.
So I will do this very
They
briskly.
found the reservoirs.
My lady has got it.
Thank you.
So the first one is the 11th of July. That's number one. The second one is the 15th of July. The third is the 16th and the 18th of July on the next page. The fourth is the 20th of July. And can you skip 2 pages and go to 637? The 5th, 6th, and 7th are as follows. The 12th of July, number 5. The 13th and the 18th of July, number 6. And the 16th of July, number 7. Now, the depths to which the drilling took place takes on some significance when you look at the next document, which is 640, which is the well workover report. Now, it's a little bit difficult to decipher. And I don't know if my lady and my lords can make out the dates. So just some preliminaries. You probably can just about make out 19 and the left-hand column. And so the report is divided into 3 sections. It begins on the 19th of February and ends on the 6th of March. Hence my comment earlier about the fact that the application to the EMA was taken midstream.
American dates.
Correct, my lady. So it's it's the month followed by the date. My lady has got it.
So it's the 11th of February to the...
The 19th of February.
It's the 19th of February, 2006.
Stroke 19, stroke 06.
So, my lord, you cannot see the month, probably.
No,
very
I got
clearly.
it, okay.
You got it. Deeply obliged. So, just taking it very, very quickly, and I did go through this evidence with I asked Mr. Archie to explain it to his lordship. You will see, first of all, in the first column, that there was an injectivity test done and no returns outside the 12.5-inch casing. And my lords, can I just interrupt myself to say, I'm a lady, to say that as far as the respondents are concerned, there was nothing in the point which seeks to make a distinction between what happened inside the well casing and what now outside the well casing. So unless you ask me to say something more about it, I'd rather leave it there, unless you want to challenge me on it or ask a question about it. We say that the judge made it very clear that there was responsibility for the emanation of hydrocarbons from the vicinity of FZ90 of 94. If you go to the second, and just again, so just to explain, open well, literally well, of course, that's opening the well. The previous reference is safety the well, and that means literally to close it in. Same lively. I just want to pause there because Mr. Archie was very helpful. That's important because it means that as of this period of time, February 2006, there is gas in the well. And this well, as you know from the evidence, has gone down to 1,200 feet. So I wish to put the kibosh right now on the suggestion that if gas can travel from 1,200 feet from the earth, it can travel 45 feet across to my client's house.
Well, going up might be rather different from going sideways, I'm not sure.
Deeply obliged, lady. At the end of the second reference, the 24th to the 26th, again, it's safety the well, so the well is closed in again. And then for the third references, which is the 1st to the 6th, I'm trying to see if there's anything about the bubble test, yes. So, well, there's bubbling, but so I'll come to the bubble test in a moment. If I can invite your attention to the 1, 2, 3, 4, 4th, 5th line. So, my lady, what's happened thus far? Second line is that Halliburton has pumped cement slurry. They've pulled the pipe up to 400 feet. They've lowered it down to 753. They've displaced the hole with 90 cubic feet of water. They've used an inhibitor, WBM, which means water-based mud. They've taken out the excess mud, which is line 4, and then they're getting what they call good returns. But there is bubbling inside. And so my point on that is that this is not just a lively well, as in the previous reference, but a well that is alive. Can I take it down 3 lines down? They pumped the cement slurry, they pulled it up to tubular to 188 feet, they squeezed 10 barrels of water, and they observed, this is important again, observed bubbles outside the 12.5-inch casing. Importantly, in the next line, no bubbles inside the 12.5-inch casing. So when you come to see or determine whether those tests that were carried out inside the casing or on top of the casing and so on, you will see that as part of the process, what was going on inside the well was very different from what was going on immediately outside of the well. And I will take you to Mr. Durant's evidence in due course, where he simply says that a well is a hole in the ground. So again, if you go another line down, no bubbles inside 12.5-inch casing. That's after the reference to EUT 308, but bubbles outside. And then scrolling down again, because we're interested in bubbles and bubble testing, slight bubbles outside, 12.5-inch casing. WOC simply means weight on concrete. No bubbles inside the casing. So you get a consistent pattern. And then again, bubbles outside 12.5-inch casing. Tucker perforated at 83 feet, and you will see that Mr. Archie refers to that in his evidence. And I can give you the paragraph in a moment. And then just taking it down to the end, after they did the injectivity, there was a breakout at surface at about 65 feet from the wellhead. So by this time, they are trying a variety of methods to seal the well inside and out. And when they, quote unquote, get good returns, then they think that they have successfully done so, because what they've done is they've used cement to block those portions of the soil that Mr. Archie describes in his witness statement as being incompetent, because it allows for the transmission of gas. And then the very last reference, 3 lines in the bottom, slide bubbles outside 12.5-inch casing and inside casing, drilled out cement, place containment chamber outside 12.5-inch casing. So that's the contemporaneous document. And if I can make good, just by the references to what I just said, I invite your attention, without reading it, to paragraphs 16, 17, and 18 of Mr. Archie's witness statement at page 630. And at paragraph 19, milady will see, if we pick it up...
page?
Easier to read his statement.
Absolutely,
which is
milady.
taken directly from the document, obviously.
Yes, milady, it is.
Which page is that?
I'm on page 630, my Lord Conworth. If you go to paragraph 19, the very last line on that page, it's not unusual or surprising. The hydrocarbons seeped naturally to the surface through veins and channels in the rocks. This would account for any seepage found in the soil around the area of the well and explains the absence of the bubbling inside the well. So he gives you his technical explanation that I have rather lengthily taken you through. Now, I know that my little friend has already taken you to the evidence of Mr. Ryan, but I do want to just...
Sorry, what are you asking us to make of this evidence? Because Mr. Archie was quite an important witness, because the judge accepted him as a credible,
Yes.
as a geologist, so
Yes.
obviously he's important. What are you asking us to make of this?
Well, there are a couple of things that come out of his evidence. The first is the distinction that I made before about inside the well and outside the well. He makes that perfectly clear. That's number one.
Yes.
Number two, when his lordship comes to this, at first instance, when he comes to assess the evidence, he doesn't really pay much attention to the cross-examination. So that if you go to the judgment looking for an analysis of this evidence,
But you're going to show us,
you will not find it.
you're going to show us the cross-examination.
Yes, you will not find it. So that what his lordship did, if I could just take you to that. So that's volume 4. It begins on page 1127.
But he goes on to explain why it happens, and he doesn't support your case.
Yeah. Sorry, my lord, could you repeat that again?
No, you're going to show us...
No, sorry, I thought you had asked me a question, whether I thought you said he supports my...
His evidence, if you just simply look at his statement, he's
Yes.
supporting the other side's case, so
Well,
you're going to show why it's...
My lord, can I make it very clear? I rely on Mr. Archie. I say that Mr. Archie and Mr. Duran support my case.
Yes, I assume you do.
Yes.
So we're gonna-
And also, so that there is no... I don't leave it unsaid, as far as the respondents are concerned, there was a wealth of objective evidence adduced by the appellants and their witnesses as to the existence of the emanation of hydrocarbon,
No, but
both in liquid and in gaseous form.
The only point I put it to
Yes.
is that Mr. Archie is not dealt with by the Court of Appeal, I think, but he's obviously an important part of your case.
Yes.
We need to see how you put it in cross-examination.
Yes.
Well, basically, he is saying there is all this evidence outside the well, but this comes from natural seepage
Yes.
from the rocks and the sand and shale generally. Of course, that leaves open what the appellant should have done about the natural seepage, which is presumably your point.
Absolutely, milady. But I go slightly further, and I say that Mr. Duran makes it clear, and I think Mr. Archie does as well, but Mr. Duran does very clearly. He says that the existence of the well in the ground makes communication between the hydrocarbon-bearing rocks and the surface easier. That's the point that he makes. And so we say that, therefore, the Petrotrin putting the well there, forget inside and forget outside for the time being, imposes upon them the duty in respect of which they were in breach, because on their own evidence, not until 1999 did they do anything about it at all.
But that was the point that the Court of Appeal picked up.
Absolutely, my lord. And I will come momentarily to the secondary point, which is whether anything done between 1999 and 2006 actually amounts to a discharge of their obligation. But I'll come to that momentarily. So, my lords, can I just make good the point I was making in relation to Mr. Archie's cross-examination? Can I invite you to page 1129? And just a couple of small points. You will see, I asked him a question about the diameter of the reservoir. You will see that at the very top, he says, difficult to say how extensive reservoirs are. Only after you've produced a well to depletion that you can get an idea of how big that container is. Some of the surrounding areas, 100 acres or bigger. I would say that these reservoirs are medium relative to country. Of course, Trinidad is a small country. This well is in a field which produced almost 200 million barrels of oil. And you could see my surprise. I say that's a lot and so on. Just again, skipping down to the bottom, where I asked him whether it was in his area of competence to say where one reservoir well begins and another ends. I trust my lady sees that, and his answer is the drainage area depends on whether it's damaged and so on, how you operate the well. The casing is a steel pipe put into the ground to keep the hole open. So again, consistent with Mr. Joran, who I'll take you to momentarily, and there he explains, cement is pumped down inside and it goes around the pipe. So my lady, I'm meeting, I know what my lady says about what's in Mr. Archie's witness statement, but this evidence is helpful and important because it provides a context broader than what's contained in his witness statement. Cement is pumped down inside and it goes around the pipe. Try to direct flow upwards. You perforate the casing and concrete so oil can get from the reservoir to the casing and then flows to the surface through the tubing. And then there's a small, he explains the smaller tubing and so on. Now, if I can just, I invite your attention to 1130 over the page at the very bottom. You will remember a moment ago I invited your attention to the rubric Open the Well, which is to be found in the well report. His explanation is probably meant some pressure in the well, could be something tested into the well or what injected didn't go. Not familiar with workover. So, of course, Mr. Archie is just trying to assist the court because this is not his primary area.
Sorry, I'm sorry to be behind.
Lord, I'm sorry.
No, it's my fault. Back to 1129.
1129, yes.
5 or 6 lines up from the bottom.
Yes.
What's he describing there? Is he describing the working of the well when it was an active well?
My lord, when you use the words describing cases of steel pipe, is that what
you perforate the casing concrete so that oil can get from the reservoir to the casing, flows to the surface through the tubing, small diameter pump within casing.
Now, what's he describing then?
Yes, he's describing how a well works. Because I've asked him, if I may say so, the sort of O-level question. Explain it to me in a very simple way, please.
So that's 1927 to 1940?
Absolutely, my lord, yes.
I thought there was some evidence of perforations during the remediation.
You are correct, my lord, there was.
What was the evidence as to why they would be perforating during the remediation works?
The reason is, the way that Mr. Joran explained it to the court was that all oil recovery works on the basis of pressure and flow, and if you are not satisfied that you have completely inhibited the movement of oil and or gas upwards, then what you would do is you perforate the casing and the concrete, allow oil to come in, and that allows you to do a sort of tracking exercise.
But that's not Mr. Archie's evidence.
Both of them say it, because both of them are talking about perforations at 264 feet and at 83 feet. But my Lord Lewison asked the question as to why.
Yes, but you're going to show us the evidence, are you?
I wasn't going to go back to Mr. Archie, but I am going to take you to Mr. Joran. It's the same, it covers the same topic.
Yes, I understood it was Mr. Joran, yeah.
Yes.
All I'm asking about is that this is 1129 that you've taken us to, is Archie talking about the well when it was working
absolutely
well between 1927 and 1940.
Yes.
Does he somewhere deal with what you do
yes.
when you're putting it right in
over the
2006?
Page. Over the page.
Right.
I apologize. I'm sorry for distracting you.
Just a bit slow, that's all.
Not at all, my Lord. So you will see, I've taken him to this, if you look at page 1130, I've taken him to or referred him to the Certificate of Environmental Clearance, and then you get the acronyms, MRRU, and he goes through them one by one, as it were trying to help me understand and help the court understand what each of these references are. I was going to skip through that and take you to 1131. And there you will see under the date reference March 1 to 6, the consequence of pumping the cement is to seal off the holes in the casing, and so sealing from the inside and so on. And then again, it is purely a sort of incidental. At the bottom of 1131, you will see the quantities of cement that were being used, 136 sacks, 187 sacks, but that's already in his witness statement. And then over the page, 1132, you will see, my lord, I'm taking him through the breakout of the perforations that I referred you to a little while ago, about those coming up 65 feet away from the wellhead at its weakest point. So if I can, my lords, move on from Mr. Archie and see if Mr. Duran provides you with some more assistance.
Did you put to him the point from the Ministry of Energy Well Workover Programme, the point from page 33 was that put to Mr. Archie or to the other witness?
When my lord says that I put the point to him, I took both of those witnesses through those documents.
It's a particular one you made with some force on page 33 of the first volume, which is the extract from the Ministry of Energy Well Workover Programme about the well bubbling around the casing. And you said you would put that to someone.
Well, yes, well, again, from recollection, I think I put it to both of the witnesses, both Mr. Duran and Mr. Archie.
Well,
am I answering my lord's question? I don't know if I am.
We'll carry on.
Yes.
That someone on the other side can tell us where that was done.
Yes. So, my lord, I was going to invite your attention to Mr. Duran's evidence. I think I said it was at, I didn't give a page reference. It's 1159.
Have we a witness statement from him as well?
Yes, my lady. I think you probably... That's to be found at page 305 to 312, tab 9. And if I could invite my lady to pick it up at 307. The very last sentence of paragraph 9, a bubble test revealed no bubbles. So this is in mid-February 2006. In paragraph 8, he identifies that there was a small area of contaminated soil and a pit located a few feet from the well itself. Paragraph 10, he refers to the installation of the blowout preventer that my lady friend took you to. And paragraph 11 refers to the presence of Mr. Cadogan as a safety officer.
So this was a bubble test before the works, was it?
Yes.
Paragraph 9.
Absolutely, my lord. So paragraph 14. Prior to commencement of attempting to drill this third plug, we experienced a very slight bubbling inside the well, and we controlled the emission of gas by displacing the well liquids to one of higher density. My lady could just cross-reference that to the well workover report that I took you to already. Paragraph 16, the next morning we bubble tested the well. This procedure simply requires that the well be topped up with water and observed for any shows of bubbles. If any are observed, then this would have indicated that the cement plug did not prove an effective seal, because at paragraph 50, they've told you they put in a plug. We observed no bubbles inside the well bore. However, we continue to observe bubbling outside the well bore. Paragraph 17, they decided to perforate the casing at 264 feet, as I've already indicated to my lord and my lady. And there's an explanation over the page at 30310, picking it up from the very last sentence. This meant that the seepage found just outside the well casing on the surface, and which caused the contaminated soil, was as a result of a source of hydrocarbons external to the well. And just pausing there, you will recall that I've already got from Mr. Archie that the source of hydrocarbons external to the well, of course, consists of the reservoirs and the hydrocarbon rocks. Paragraph 18, Again, constant use of the word seepage. In order to seal the hydrocarbon-bearing sands, which were the source of the seepage, cement was pumped into the well and squeezed into the perforations. We eventually started to see areas of mud bubbling up outside of the well, indicating that the rock formation around the wellbore was weak or incompetent. Paragraph 20, the next bubble test. This is 2 of 4 for your note. The next day, we again performed a bubble test. No oil or gas seeped from the wellbore. The plug was tagged. We checked to see how deep the plug was by using a pipe. We continued to see evidence of oil seepage outside of the well. So again, just pausing there, consistent with the bubble test of what's going on inside the wellbore, there is bubbling outside of the physical wellbore. Paragraph 21, they perforated at 83 feet. I won't take you to that. Paragraph 23, bubble test number 3 or 4. The next day, we again did the bubble test and found only a slight seepage inside and outside the casing. So in this occasion, the seepage has moved across both, but there is still some seepage. Paragraph 24, they took out the cement, and then paragraph 25, the 4th of the bubble test. Another bubble test was done in the presence of officials of the Ministry of Energy. This time, the test was done by pouring water into the wellbore and by digging a pit around the circumference of the casing of the well. It's 12 feet in diameter, 7 feet in depth. Water was also poured into the pit. There was no evidence of seepage of oil and gas. So at that stage, they finally got the well completely under control, and in paragraph 26, they weld on the the half-inch steel plate. That's, unless my lord and my ladies ask me to do so, that saves me the necessity of torturing you, in fact, with the cross-examination to be found on 1163, 64, and 65.
Probably elect not to be tortured, I suppose.
But I mean, the particular point which you, at page 33, the Ministry of Energy report says the well is bubbling around the casing about 3 feet away, contaminates an area around 6 feet around the casing, oil flows to the main and so on, and has been in place for several years.
Yes.
Now, you are relying on that,
Yes.
and that's not precisely what this witness says, so presumably you put it to him that his evidence was inconsistent with that.
My lord, I didn't. I didn't put it to him because I didn't need to. In other words...
You're not relying on that.
Sorry, my lord?
You can't rely on that document without putting it to the witness.
Well,
I mean, if you're relying on the witness's evidence, fine, and we can leave it there.
Well, do you accept my Lord's premise that this is inconsistent evidence?
No, I don't actually, with
think
respect. No, I actually say it's consistent with it. I say it's consistent with
I
it.
had no idea. It's the
No, I'm
first time
sorry.
I've seen it. But presumably you have to put it to the witness in fairness, give him a chance to deal with it.
Well, it's their document, my lord. So it's their document. I say that it's an admission.
Anyway, there we are.
But, well, my lord,
You say that both documents are consistent, surely.
I do. In fact, I go further. I say that the documents, i.e., the original application, its purpose, as stated, the program, what is contained in the program, and the narrative as well as the report evidence of what happened in the well workover program, I say that they are all consistent.
Yeah, all right, well, I understand that. But I'm not going to torture myself by looking at the cross-examination if I'm not going to find this point being put.
But,
My lord,
Mr. Benjamin,
My lord.
you do need to torture us, surely, with the final answer on 1169, which you rely on, as I understand.
Absolutely, my lord. So thank you for that. So this is an answer given to his lordship, where he asked the question at 1169, very last question, does the fact that a well was dug there make communication between the source of the oozing and the surface easier? And the answer is yes.
Yeah, well, that I understand.
So, my lords, that's what I want to say in relation to the program. Can I now just close off on an observation I made in relation to the testing? Because I drew your attention to the fact that the testing took place in April of 2006. And my learned friend has not invited your attention to any pre-decommissioning report. He hasn't put before you any document. He hasn't invited your attention to any pre-commissioning testing report. We have the narrative evidence of Mr. Cadogan, which I'm going to deal with, but there is no report. In other words, whereas in April 2006, in order to satisfy themselves, and perhaps Mr. Ryan, because he did ask about this, that the effect of the decommissioning exercise was successful, whatever might have happened internally was not, as it were, made apparent, i.e., my Lord Wilson asked this question earlier of my learned friend, was there testing pre-decommissioning? And I go further. Is there any report? No, none has been produced. What my learned friends rely on, if I might call it, this is inferential secondary testing. They say that the testing done by Mr. Cadogan for the purpose of ensuring that nobody got blown up when welding was done, because I've already dealt with bubble testing, when welding was done, that allows the court to infer that because even though they were only testing for a limited number of gases for a very specific purpose, that it follows from that there was no gas present. We say respectfully that that's not consistent with document that I showed my Lord at 33. It's not consistent with the program, and it's not consistent with what happened in the course of the program, and it's not consistent with the scale of the program. But because I've got your attention on 1160-something and so on, can I just invite your attention to 1167? I asked the question of Mr. Joran, the only petroleum engineer to give evidence. My lady will see this, just 6 lines from the bottom. Would it be correct? Would it be correct that crude petroleum carries with it a variety of volatile organic compounds? Answer, yes. Did you carry out any testing to determine the level of volatile organic compounds there? Answer, no. Methane, ethane, and propane are only some of the volatile organic compounds. Answer, yes. On a subsequent visit a year later, did you carry out any tests? And the answer, no. And over the page, we close off those questions. You didn't have any of yours dug up and sampled, but we know Kaizen did it. And can you confirm that the Ministry of Energy satisfied itself by being present at the end of the process? Answer, yes. And then, out of fairness, and the only test carried out for the presence of gas was the test carried out by Mr. Cadogan and the bubble test. Answer, yes.
Now,
my Lord.
Can we just concentrate on the 4 gas test?
Yes.
That's Mr. Cadogan's test, isn't it? Would you turn up 37 of the Court of Appeal's judgment, paragraph 37?
Paragraph 37.
It's in 2 different places. I'm afraid I've got it in the 1400s, but it's also, I think, in the 2500s or somewhere.
Yep. 2513, I should think.
Thank you very much. But paragraph 37, anyway.
Paragraph 37, 2532, yes. I got
2503?
No, that's the...
It's 2532, my lady.
2532. Thank you. Now, this is the Court of Appeal saying at 37 of the Cadogan gas test that the judge got it wrong because he'd misunderstood the limited kind of testing that Mr. Cadogan was doing.
Yes.
Which is, I think, the point that you've just been making.
I tried to, my lord, yes.
Right. His evidence did not show that he tested for all VOCs. Well, we can see that from page 1167 that you've just taken us to. More specifically, he was only testing for methane and not, for instance, for other VOC gases like hydrogen sulfide and sulfur dioxide. Now, is that correct or is that wrong?
I have to accept that as a matter of evidence, that's not right. What I mean by that is that neither hydrogen sulfide nor sulfur dioxide are volatile organic compounds.
And he was testing for them.
And he was testing for them because
They
that's...
are nasty things which get into your, if they get into your lungs, might, subject to the medical controversy, not do too much good.
My lord, I'd go even further. Sulfur dioxide and hydrogen sulfide are highly dangerous.
They're both
One is
poisonous.
corrosive.
They're both poisonous, Bob.
Yes, absolutely. So that you're exposed to them, you probably know it within minutes.
Yeah.
And if you're overexposed to them, you're going to be very ill, if not gravely in danger.
Well, maybe. But at all events, this criticism of the judge is simply wrong, is it?
It is wrong to the extent that, or let me put it this way, my lord, if I put a full stop after the word gases, it would be right.
Yes.
So
After VOC gas.
absolutely, my lord. So that's the best that I can do.
Right.
That's the best that I can
Very
do.
much. That
I thought he said he did test for other VOC,
He did not, my lord. He actually said that somebody else did, but he didn't say that he tested.
but not him, someone else did.
Yes, that's what he said. And that's why I make the point, well, let's see the color of your testing, so to speak. And my lord, while you've got me on paragraph 37, can I just, as it were, endorse or support what the next sentence, which is something that I did put specifically to the medical witnesses, Mr. Simangal and I think Mr. Coombs. And in any event, we know that Mr. Cadogan, they form part of the 4 gases that he was looking for. Well, I'm just having a quick look at Mr. Cadogan's cross-examination to see if there was anything else. No, I don't think that there is, that I wanted to draw. I apologize, just 1 second. Yes. I don't think I've taken you through that evidence, have I, the cross-examination? Can I do that now, for completeness? It's to be found on pages 1148. And just for your note, but you probably already have it, the first of his 2 witness statements is to be found at page 300. And I don't propose to take you to it unless you ask me so to do.
What are we looking at? Cadogan's cross-examination?
Yes, my lord.
No.
I apologize for not making that clear. Can I pick it up at 1149? At least I hope yes, 1149. In the middle of the page, under the reference to the photograph, when you went there on your first visit, you saw with your own eyes oil in the vicinity of FZ 1994. And over the page at 1151, would you agree the seeps of oil was reasonably close to the well and well casing, but not in or on it? Yes, and you would have noticed the drain dug for the purpose of allowing seepage to flow. And importantly, and I will take you to other witnesses who say the same, you saw oil-affected soil on the ground, seepage from the drain itself. Yes, correct. And you also noticed oil in the pit and so on. And at the bottom of the page, you will see there's a reference to making complaints to the health environment and how they get mobilized. And then over the page, 1152, on testing, and again, just context at the very top of the page. I won't read it to you. But in the middle of the page, I asked him whether he was part of the process seeking EMA approval. My input as a safety person was never sought. Exposure limits, no. Asked whether any information in relation to Mr. Ryan's health. Did you have any? Answer, no. Or medical reports resulting from the testing of Mr. Ryan or Athena Ryan? Answer, no. And he, having asked him those series of questions, he confines the next answer. Measurements taken by me were for the purpose of the hot work permit, to ensure no danger of explosives to men working there. And then I tax him on the suggestion he makes in his witness statement that he regards the complaints made by Mr. and Miss Ryan as to be without merit, but he doesn't actually know what they are in any detail.
Yeah. Okay, so you've established that there's some gas coming up prior to the remedial works in 2006.
Yes, ma'am.
But the judge accepted that, didn't he?
Yes, he did.
It's certainly accepted that there was oil coming up. That's paragraph 177. And the most that he said about gas was, at 183, yes, there was oil, but there isn't enough evidence to justify the conclusion that there was enough gas to do any damage. Now, what's wrong with that? Where's he gone wrong?
The first step in which I say he's fallen into error is he doesn't actually refer to the evidence or acknowledge the fact that gas was present both inside and outside of the well. So, my lord, this is significant for me because what we say the evidence discloses over an extended period of time is the release of hydrocarbon emanations. I'm just going to leave the distinction between gas and liquid just for the moment.
Yes, sir.
And we say respectfully that that evidence is clear from that of the defendants, sorry, the appellants, from at a minimum 1999 to 2006. We say further that there is no indication that what was discovered, and I use that in inverted commas, in the course of the remediation works, i.e. the lively presence of gas, did not represent a characteristic or feature of the well for that entire period of time. I don't need to go beyond 1999 for the purpose of this argument. So we say respectfully that what the judge ought to have concluded based on the totality of the evidence, i.e. the totality of the defendant's evidence, of the appellant's evidence, was that A, there was an objective body of evidence pointing towards a sustained, I'm not going to say significant, a sustained presence of gas, and by that I mean sustained over time. Because the alternative conclusion would mean that the phenomena that was observed by Mr. Juran and Mr. Cadogan and so on was unique. In other words, it just happened to occur over the period of the 19th of February to the 6th of March. And we say that's completely untenable as a matter of common sense and logic. So that's the presence of gas. And there's been lots of evidence about smelling and noses and so on. I'm not going to go there, but let me just turn now to liquids. So the same evidence, i.e. the evidence of starting with Mr. Rupchan, going to Mr. Sankasing, going to Mr. Julian, going to Mr. Cadogan and everybody else, objective evidence, in other words, what they were going there to do. Mr. Julian is a health specialist, a safety specialist, they are going there to remediate. So that on the appellant's case, in order for them to be right, my lords and my lady have got to accept that a company, a state enterprise, it is true, undertook an exercise that, according to the documentation, costs upwards of $200,000 for no reason at all. No reason at all, because there was no gas. That's the argument that's being suggested. And so what we say with the greatest respect, that flies in the face of commercial common sense. And no one has advanced an alternative explanation as to why an exercise of that, an exercise of that nature and magnitude could possibly or responsibly have been undertaken.
It's 200,000 Trinidadian dollars.
No, no, 200,000 US dollars.
US dollars.
I can give you the exchange rate if you wish.
Yes.
7 to 1
Yes.
in the non-black market, the legitimate market. So we say an expensive, complex, technologically advanced exercise, which on the appellant's case had no rationale for it. And we say that with this respect to the learned judge, that if he had adopted a line of reasoning that mirrored what I just set out to you, he could not possibly have come to the conclusion that he came to. I say with respect, with great respect, that the Court of Appeal was right, because the learned judge, in coming to that conclusion, came to a conclusion that no reasonable judge could come to in light of, this is an important phrase, all of the evidence. My learned friend has hung his hat on exaggeration and the Ryans and subjectivity and who smelled and who didn't smell. But the forensic process means, with respect, that the judge has to deal with all of the evidence. And if he's going to reject an argument or he's going to reject a portion of the evidence, he cannot do so partially. He can't look at only some of the evidence and come to an adverse conclusion.
Would it have been open to him to conclude that even though there was no evidence of the seepage of gas, a highly conscientious company, guarding against even the remote possibility of it, might well be prepared to invest $200,000 US?
Well, my Lord, two answers. One, my Lord's inventive suggestion was not put by anybody. And secondly, that's not the evidence. In other words, there was...
But you're inviting us to conclude that the circumstance that the appellants undertook this exercise is itself demonstrative of evidence of the seepage of gas.
Yes, my Lord, I am. I am inviting you to do that, but I'm not inviting you to confine yourself to that process.
Oh, no, I appreciate that that's only one strand of the argument.
Just have a very quick look at page 24, would you, and reassure me that it's simply a misprint when it says Trinidadian dollars.
I suppose thanks.
Right at the bottom of the page.
Yes,
correct?
I see it.
It's a misprint, is it?
I think so, because I've seen US somewhere else, but I can't...
All right, well, don't worry about
yes.
it now. That's where I got it from. That's
Yes, no, I didn't think for a moment that you didn't have a sound basis for doing so. My Lords, I was on... Can I just have one last look at one final page in Mr. Cadogan's evidence on 1154? My learned friend did take you to some of this in the course of his address. And I say the last two questions. Why would there have been vapors coming out after the reabandonment process you talk about, clearing out the wellbore and so on, into it to seal that area again? Yes. Why would there have been vapors coming out after cement was put in, but no vapors before cement was put into the wellbore? And the witness says quite candidly he can't answer the question. But the judge is simply putting the scenario to him about the presence of vapors. And again, for completeness, 1156 and 1157, I think my friend took you to this already, so I won't repeat the exercise.
Yes, we've seen all that.
I'm deeply obliged. And just one last question, 1158. In the middle, rephrase, those gases were tested for, once none detected, there were none, and you weren't testing for all VOCs in existence, just methane. Can I just make good what I said to you about Mr. Rup Chan, and invite your attention to 610. I think that's right. And it's just really at the top of the page. So 610, tab 21, my Lord, Conworth. It's paragraph 5 of his witness statement. So Mr. Rupchan, as my lords and my lady know, went there first, and it's simply to make the point, when the grass was cleared, I observed a slight oil stain approximately 6 inches away from the well casing. The stain was approximately 12 feet in diameter. Now, just pausing there, my lady, and to simply say that my friend took you to a reference to the evidence of Athena Ryan, who described a small lake. And all I wish to show you is that the evidence of the appellant's witnesses is consistent with what Ms. Ryan was saying. She said she used different language. She said she saw a small lake. Here is somebody saying, I saw an area of an oil stain that's 12 feet in diameter.
That's in 1999.
That's in 1999.
Oh, absolutely.
Yes.
Absolutely. And I could go further. If you want to come forward to April 2006, we can go back to page 400 and the Kaizen test. And so here you have Kaizen doing their testing in April 2006, and they are still able to demonstrate or to show on the drawing the presence of oil stains. And that's after the remediation exercise is complete. So that
What's meant by an oil stain and what's meant by a slight oil stain? I mean, 12 feet to me is, quite a large puddle.
yes.
But does a stain mean a puddle, or does it just mean sort of traces of oil on the ground?
The way that the witnesses, I don't know whether this was, the way that Mr. Cadogan in particular, Mr. Duran explained it, they simply said, oil on the ground, it consists of a variety of hydrocarbons, and those of a higher volatility are going to evaporate. So once they evaporate, the end result on the ground, unless it's of great depth, is going to be a stain.
That's what it says at the end of paragraph 5 on page 610. After evaporation, what's left is a stain.
I've got a reliable source model.
So it's discoloration on the ground surface.
Yes.
Okay. It's not a puddle.
It doesn't remain as a puddle. It may start off as a puddle.
Well, it might.
It may start off as a puddle, but it transforms into something else. The very same point can be made in relation to Mr. Sankar Singh at page 623 to 624. Paragraph 4, just the first sentence. So Mr. Sankar Singh, as we know, went there in 2001. At the time of my first visit, I observed no visible pooling of oil outside the casing of the well. The only visible evidence of seepage was the darkened patches of soil in the vicinity. And Mr. Julian at page 295. So I said 295, but in fact it's 296. At the top of the page, in small areas around the well, there appeared to be clumps of soil mixed with oil seepage. There was also a pit filled with water. The surface of the water was covered with a very thin film of oil. So again, my point, my lady and my lords, is that of consistency. So do you have a consistent picture of the presence of oil and gas as a result of all of this evidence that we have looked at over the entire period of time? And can I just make good one other point on consistency, which is, as I've said to you a moment ago, I say with respect that the evidence given by the defendant's witnesses, by the appellant's witnesses, was not inconsistent, I'll put it like that, with that of Ms. Athena Ryan. But similarly, in relation to Mr. Stanley Ryan, paragraph 5, page 172, before February 2006, as well as after, the defendant wrongfully caused oil to seep from the said oil well. So to the extent that it's being suggested that there was wanton and flagrant exaggeration across the board, as far as the evidence is concerned, that's not a complete picture. And so you see a consistency of language across the witnesses. So can I turn from that evidence and say something about the medical evidence? First of all, of Dr. Trotman. Now, her evidence is to be found at page 288, I believe. And I know that my little friend has taken you, I think, to some of it. So it begins in 285. That's where you have a witness summary. And just for your note, if you, as it were, look ahead, I will take you to the cross-examination at 10:59. Now, my lady and my lords, I know that there was an exchange about, I suppose, the relative merits, strengths, qualifications of the respective experts. So just for completeness, if you look at page 287, you will see that Dr. Trotman is a specialist. And if you look at the letterhead, whether it's on 287 or 88 or any of the others, you will see that she also has academic responsibility. She's an associate lecturer at the University of the West Indies in internal medicine, chest medicine, etc., etc. So we say respectfully that the submission made by the appellants that Dr. Coombs and Professor Simangal were entitled to have their evidence treated in the same manner as that of Dr. Trotman and Dr. Bagan-Khan. We say that's without foundation. What we say respectfully is this. This is not an academic exercise. These are patients. These individuals have clinical responsibilities. Professor Simangal was specifically asked to express an opinion about the etiology of Mr. Ryan's disease. We know he had nothing to say about Miss Ryan. Similarly, Dr. Coombs had nothing to say about Miss Ryan. So whether it's described as professional or intellectual or academic curiosity, they didn't express any. And so what we say respectfully is that what the judge ought to have done is put aside the question of relative qualifications, as I think he probably did, and look to see whether they, i.e. the experts, could help him. That's Part 35 compliant. I can't remember the number of the English part of the CPR, but I'm confident that the language is identical. So that was their obligation. Their obligation was to provide cogent, persuasive evidence that assisted him. And the way that they could have done that properly was by asking for the opportunity to examine Mr. Ryan or Miss Ryan, and then expressing an opinion. To the extent that Professor Simangal did not do that, then his opinion is essentially abstract. It's up in the air. It is true that he, how do I put this fairly? It is true that he doesn't have a significant quarrel with the diagnosis of Mr. Ryan as suffering from pulmonary fibrosis.
Yes, the question is not so much one of diagnosis, is it? That was not seriously
Absolutely.
disputed. The question is, as you say, the etiology, which is to some extent a matter of evidence and literature and all sorts of other things.
So we say respectfully, he doesn't get near the evidence because he didn't look at it. He didn't inquire of it. In other words, my lady, I put it like this. So even assuming that Professor Simangal has in front of him the entire bundle of Trotman and Bagan-Khan reports, he says, as I think any responsible clinician would do, that's all very well and good. But I need to satisfy myself. Now, it doesn't mean that he's necessarily going to order a CT scan or conduct a spirometry test or ask for pathologists to look at something again. He may take all of those things as read, but he would, properly speaking, satisfy himself by simply taking a comprehensive history.
Do you,
And
Trinidad and Tobago, does the court have to authorise the bringing of expert evidence?
Yes. Yes, it does. But I have to be candid. This case was, I don't recall whether we made applications. I don't think we did. In other words, my learned friend and I on the other side, Mr. Martin, who was very senior silk, we operated in a cooperative way, and we didn't, as it were, force one or the other to make an application.
Let people do that in this.
Well, can I tell you now that it's not done anymore in Trinidad? But at that time...
Precisely because it's then possible for the court to say, if either the claimant or the defendant wish to adduce expert evidence, what it is for.
Yes.
And of course it is very frequent, certainly in the jurisdiction in which the three of us started our full-time judicial careers, to have a paper review of the clinical evidence given by the people who'd been actually treating and looking after. In our case, it would normally be children, sometimes their parents, and bring a sort of objective outside. Academic is the wrong word for it, but
thorough,
scientific basis for the opinions expressed by the treating clinicians. That's a very common exercise with us.
My lady, candidly, that at the level of rigor hasn't yet arrived in Port of Spain. It's coming because there are...
I'm sure you'll bring it there, Mr.
Well, but we're not there yet. I mean, my own immediate personal experience, I was involved in a case involving a cerebral palsy child. And the process that my lady just described did not happen at all. And there were possibly 20 experts on either side in that case.
But are you suggesting that the evidence that the respondents called on the trial is in some sense devalued because they didn't conduct an examination of the claimants?
Yes.
Well, why? I mean, if there's no dispute as to the diagnosis, then it's a question of etiology. It's a question of whether, given the known circumstances of the case, this admitted condition could have been caused by the circumstances that the claimants allege.
Because the answer to the etiology question would have been better informed by the very process that Dr. Trotman and Dr. Bagan engaged in. For instance, Dr. Trotman saw Mr. Rand possibly 5-6 occasions.
Yes, but why? Why would it have been better informed?
Because, well, if buried in my Lord's challenge to me is, well, what would Professor Simangal have asked? What would his inquiries have been? I simply don't have the expertise to make even a guess at that. But I would respectfully submit that the quality of what ultimately he did was impaired by the fact that he didn't take advantage. All he needed to do was ask.
Ask what?
Ask for an opportunity to see Mr. Rand. That's all I meant, sorry.
But having done that, what's he then to do?
Well, my lord, I'm not in a position to answer that question. I'm not a pulmonologist. I simply wouldn't know what would be the nature of the inquiries that an expert, highly qualified professor of medicine is going to ask. But I am confident, just by looking at his report, that he would have had a ton load of very sensible and probing questions. And you see, my lord, when you go back to the report, you can see him engaging in this slightly artificial Wimbledon-like dialogue with Dr. Coombs. So he poses a rhetorical question. He doesn't get an answer. So we say respectfully, I don't want to put too much of the weight of the argument in this respect on that. But I do want to stress or emphasize, if I may respectfully, that Dr. Trotman's position was the obvious. In other words, her primary activity was that of a clinician who also had an academic interest. She is supported by Dr. Bagan Khan, who is a clinician of some 10 years experience. If you look at the supplementary witness statement, you will see that she was a registrar and so on. I mean, I know that there's been an attempt as it would diminish her occupational health qualifications in the text that she used and so on. But what we say is that what Dr. Trotman was doing was saying, this is a condition that I have seen, and that's why I came to the conclusion that I did as a result of the inquiries and the questions that I asked, my lord.
I don't think she was she saying that she'd seen cases of demonstrated hydrocarbon gas-induced pneumonitis?
My lord, in the break, I was actually looking for the answer to that question, and I couldn't find it. I'm confident that it's there.
Is it?
I thought
Well,
it
if
was.
it is,
My
it is,
lord,
you can
I
take
said I couldn't find it, so I have to say that I don't know where it is.
Okay.
Yep. But my lord, just going to the cross-examination, just very, very briefly, I've already made my points about the tests and the inquiries that she made. And what I would like to do before I look at the cross-examination of Professor Simangal, which is a little bit more important to me, is to commend pages 1069, where the judge begins to ask his questions and his clarification, 1069 to 1072, without reading it out to you, if I may. Now, and before I go to Professor Simangal, can I just have a quick look at the text? So, in other words, just to make a few respectful submissions about the text that Dr. Bagan Khan put before the court. Now, my learned friend made great stress on the fact that she said that she could produce text and she only produced one. What we say is that the text, the fact of the text, and this is how these things sometimes go, has to be seen in contradistinction to journals, reports, academic studies, and so on. In other words, whatever the state of medical knowledge and whatever its future is going to be, clinicians have to try to treat their patients as best they can, and they use what tools are available to them. So the fact that a text comes from one side of the Atlantic as opposed to another is neither here nor there. What is made patent by the evidence of Dr. Trotman and Dr. Simangal is that the level of scientific certainty about the relationship between hydrocarbons on the one hand and pulmonary disease was very much, how shall I say, I don't want to say up for grabs because that's what the judge said, but certainly it was not at a state where everybody knew the answers to the burning questions. You're not in a situation, as might be the case in respect of some other pulmonary diseases, where everybody knew the answer. And I can't at the moment put my finger on the text, but can I just make the submission while it's in my head? My lady, in relation to the text, I want to reinforce my submission about practicality, because what the text was doing is address the clinicians, saying these are the radiographic, thank you, these are the radiographic findings that point to a particular source. And it's, in a sense, slightly ironical that you have 1, 2, 3...
Sorry, which page are we on?
I'm sorry, page 507, my lord.
Thank you.
So page 507, as I said, so the text is the handmaiden of those who are, as it were, in the front line. It's pointing towards, it's not an academic study, it doesn't tell you statistics, it doesn't tell you anything of that sort. That's not its import, that's not its intent. But importantly, identifies hydrocarbon pneumonitis, hydrogen chloride, hydrogen fluoride, hydrogen sulfide. And those are some of those chemicals we have seen before because they have adverse health effects.
It's a very curious list, this, isn't it? Because some of it is referring to substances,
Yes.
and some of it is referring to diseases. So you've got fire smoke,
Yes.
and you've got hydrogen chloride, hydrogen fluoride, hydrogen sulfide, hydrogen
Paraquat.
phosphide, and in the middle of all of that, you've got pneumonitis.
Yes.
And
So
it's very weird.
it is strange, and what one would have thought might have happened. So if I can invite you to draw a line that starts at acetaldehyde and separate that from zinc chloride, because the radiographic pattern is different. So that's how they are grouped. Now, my lady, as you might
Sorry,
suspect,
where do you want us to draw the
so
line?
draw the line above acetaldehyde,
Yeah.
because what follows in the list beneath goes
Acetaldehyde.
with diffuse infiltrates, acina, alveolar pattern, including pulmonary edema.
That's what you see on the radiograph.
Absolutely.
And the right-hand side is, as you say, simply a list, some of which are
Some of which are, as I said,
substances and others are conditions.
absolutely.
That's what's
And
difficult to interpret about this table.
well, the table was only produced for a single purpose. Dr. Bagan Khan was challenged frontally by my friend on the other side as to where she got what she was saying from, and she said, it's in a text.
It's produced, isn't it, to demonstrate the existence of a condition known as hydrocarbon pneumonitis, which was in dispute.
Absolutely. Hotly disputed.
And it doesn't do that, does it, except to say that someone has put those two words together in this list.
Well, my lord, I say with respect, and my respectful answer to you is that it does do that
How?
simply by linking three things together. A, the radiographic pattern, and B, hydrocarbon, and B, C, pneumonitis. And all, my lord, I understand my lord's reserve, if I could put it like that.
Well, what you can say is that somebody at least thought that hydrocarbon pneumonitis was a known condition.
Or I think I can go a little bit narrower than that. Or I think I can say with confidence that there is a specific radiographic pattern that points towards hydrocarbon pneumonitis. That's all that this is seeking to say.
No, you simply can't say that. That's not,
Sorry,
what,
Lord,
that's,
I
not what
apologize.
that's not what it's saying at all. It's saying that when you have all these many different things,
Yes.
what you tend sometimes to see on the radiograph is diffuse infiltrates, etc. Doesn't mean that they're an indication of it.
Oh, yes. So I accept my lord's, as it were, qualifications. So all I say that each of these is an illustration of this specific pattern.
All right.
I don't think I can go further than that. So, my lord, can I take you now to the cross-examination of Dr. Simangal? And that's to be found on page 1185. That's how it begins. He is shown the text, as you can see, over the page at 1186. And you will see at 1187 a series of questions I asked him. If exposure,
Sorry, which page is this, please?
1187, my Lord.
1187.
Yes.
Oh, yes, thank you.
So 1187. If exposure about which patient complains is hydrocarbon-based, clinician might conclude patient suffers from hydrocarbon pneumonitis. Answer, yes. You yourself, he says yes. You yourself have not come across the term hydrocarbon pneumonitis. Yes. You make use of the internet. Yes. Term hydrocarbon pneumonitis being unfamiliar. You did not search for the term hydrocarbon pneumonitis? No, I did not search for that. I have never done so. Question, not even when lawyers from Petroleum drew the extract to your attention? Answer, no, yes, I did over the weekend. I was not surprised by a response. I got responses. This was the first time I saw the term, having got responses over the weekend. I did not print out any of the search results. So just pausing there. So the professor goes into the box. He says that he did it, but he doesn't bring any of it to court. I don't know. I would submit respectfully, my lady, that that's not, again, I keep on forgetting which part it is here, whatever part of the CPR, and the practice direction, and the protocols, and the learning, that's not compliant. That's my respectful submission. And then I asked him a series of questions about hydrocarbons and so on. And I put it him over the page that, a place like Trinidad is where they occur naturally, et cetera, et cetera. I'm interested in particular with the questions at the bottom. Agree that hydrocarbon exposure can be toxic. And hydrocarbon exposure being toxic can affect many different organs. Depending on the level, if high levels, lung being the first organ to experience it, they may be most affected. And its answer, I have limited clinical experience treating anyone as a result of hydrocarbon exposure. And then over the page at 1189, so he says that based on his internet research, did you come across any of this in your research of the weekend? Because I asked him a series of questions. And he says, yes, asphalt exposure in children, not adults.
Sorry, where are you looking now?
Oh, sorry, my lord, I'm in 1189.
Yes.
So asphalt is in the range of hydrocarbons. Please bear in mind, my lady, that Trinidad is the place where the Pitch Lake is located. So we have hydrocarbons by natural gas, we have hydrocarbons by way of oil, we have hydrocarbons by way of asphalt and bitumen. That is native, if I could use that phrase, to our country. And everybody, every primary school child would know what I just told you. Now, I then asked him, would you accept from me that Dr. Trotman sees people in her practice who suffer from hydrocarbon pneumonitis? My Lord Hughes, that's one of the places, but I know I got it somewhere else as well. And he wouldn't know, and he does not. And then I asked him about the text and so on. And then I specifically put to him that the one thing that was new to him was hydrocarbon pneumonitis. And then I took him through the various tests that were done and so on. Over the page, starting off with the bronchoscopy, which is in the middle of 1190, the physical exam, the EA test, the CT scan at the bottom of 1190, and the spirometry, etc., ending with the reference to the pathology done by Dr. Janke in the middle of page 1191. All right, and then I asked him whether he's been to Hickland Village, and he hasn't seen FZ94. So to the extent that the experts for the respondents are to be the subject of criticism, legitimate or otherwise, because they didn't go to Hickland Village, we say that what's sauce for the goose is sauce for the gander. Professor Sibangal and Dr. Coombs did neither. They neither went, nor did they examine them. And over the page 1192, what you have this already, in the middle, not quarreling with Dr. Khan and Dr. Trotman saying that he has fibrosis, not quarreling with Athena having reactive airway disease, have seen no test, recall, etc., etc. And then just going back to the issue that we're on, so my friend took you to, I think, these two passages. I hope that's right. In 1193, I think my friend did. That's the article from the Journal of Occupational Safety and Health. I asked him whether he had come across it. It deals with the petrochemical complex. And that, too, is part of the landscape in Trinidad and Tobago because that's what you use natural gas to do, produce a number of derivative chemicals. And so I asked him the question, is it that you have been able to make the link between pulmonary fibrosis and exposure in a petrochemical environment? Answer, yes. Is the full answer in that, in fact, you have come across a link between pulmonary fibrosis and exposure in a petrochemical environment? And then he says, clinically, I have not seen any case of pulmonary fibrosis which I can link to exposure to hydrocarbons. And he says what he has seen, acute respiratory diseases, and tend to see patients when they're symptomatic, etc.
Page, please.
I'm sorry, my lord.
My fault.
No, 1193. 1193.
Good.
Yes. And then at the very bottom of the page, low level of fibrosis, and it's connected, linked to petrochemical industry. Yes, I've seen that, but not linked to hydrocarbons. I've seen...
Simon.
Yes. Is my lord with me?
Right.
No, I apologize again if I'm going too fast. And then what he does say by way of... Perhaps I don't want to overstate it, by way of a concession. Over the page on 1194, yes, I have seen, but not linked to hydrocarbons. I have seen other disease, not linked to exposure to hydrocarbons. Even though they work there, their condition is not linked to the environment. More comfortable with the term hydrocarbon exposure. Never seen link between hydrocarbon exposure and lung disease. And then he refers to the paper about rabbits. Well, again, using without overstating the case, the the New Zealand paper on rabbits certainly does permit one to begin to say that there could be, in human beings, a link. That's a paper that he found. It's referred to in his witness statement. We simply drew to his attention other literature that, as lay people, using the internet, Googling like everybody else, we drew to his attention. And specifically, I rely on the fact that when Professor Simangal conducted the search for hydrocarbon pneumonitis, he accepts and admits that he got results, he just doesn't share them with us.
Now, you clearly persuaded Judge Smith about this, and the relevant paragraph is 30
Yes.
in the Court of Appeals judgment. 1448 is my numbering. It'll be about 2528 or something like
Yes,
that.
it is.
You can pick it up halfway down paragraph 30.
Yes.
Dr. Simangal's opinions.
Yes.
Seriously discredited,
Yes.
says the judge, by
Yes.
cross-examination. And he revealed, ... a recent internet search revealed such a link.
Yes.
And the link he means is a link between pneumonitis and fibrosis to hydrocarbon fumes.
Yes.
He says the same thing again on the next page, in the second half of paragraph 31.
Yes.
Dr. Coombs' evidence is open to question because it was based on his researches of the literature, which must have been deficient in the light of the admissions of Dr. Simangal, whose researches eventually found links between hydrocarbon exposure and lung disease. Now, what's that based on? Is it based on 1187? I did it over the weekend, and I turned up the words hydrocarbon pneumonitis as an expression.
In part, yes.
Anything else?
All of it. All of what I just took my lords through.
I see. Right.
My lords, please,
I've got it.
Yes.
That is
Yes.
where it comes from.
So that's where it comes from.
Right.
Because, well, respectfully, there would not have been anything else.
Okay.
Obliged, my lords. So, my lords, unless you ask me to, that's all I really wanted to say about the medical evidence. Let me just kind of double check my references. And I hope that I've tried to assist you as best I can in relation to the testing, and I've taken you through, as I intended to, Mr. Duran's evidence, and I've made my point to you about the well. And I don't know how I'm doing for time. I'm probably close to the end.
Yes, you've got at least 5 minutes.
5 minutes. Can I respectfully make a quick submission about the law? I don't pretend for a moment you actually need my help on it at all. But I do want to say one quick
That's
sentence.
a very beguiling submission.
Not at all, not at all, not at all. I say respectfully that the respondent's case is a matter of law, is, and forgive me for my shorthand, I don't mean to be disrespectful, is Lord Reed in Bonington, semicolon, Lord Reed in McGee, and the magisterial analysis, although he was not alone, of Lord Bingham in Fairchild. And what I mean by that is either I get home on the first one half of Justice Verbeil Smith's judgment, or I say I get home on the second half, the last 1/3 in fact, which is the material contribution to injury alternative by way of a relaxation of the policy, of the rule as to causation. And the second half of my submission, with great respect, and I do need to have Justice Verbeil Smith's judgment in front of me, if I can find it. I say respectfully that Justice of Appeal Smith and Justice of Appeal Smith alone of the judges, i.e. he had concurrence with a Justice of Appeal Musai, but Justice of Appeal Mandanza doesn't deal with the point at all, was entitled to conclude that the common law of Trinidad and Tobago, as a matter of policy, could adopt, to the extent that it's not already part of our law, could adopt what I would call Bonington Part 2, McGee Part 2, Fairchild Part 2, i.e. material contribution. Because that's what he does at, I think it's paragraph 61, 62. No, it's 62 and 63. So I commend to my lords paragraph 62 and 63, and I do so to the extent that it's absolutely necessary, because as my lady and my lords will recall, in our written case, we relied upon Lord Toulson, may he rest in peace, in Williams. So we say the likelihood is that it's part of the law of Trinidad and Tobago already as a result of the decision of this board. But to the extent that it's necessary, and to the extent that, I don't want to overstate my case, that Justice of Appeal Smith was looking forward, and to the extent that he might properly have anticipated what my Lord Toulson might have said in a different case altogether, we say that he was fully entitled so to do, and we would ask my lord and my lady and my lords, I apologize, my lady and my lords, to endorse and to respect that policy choice. Unless you have a very, very difficult question to ask me. That's as far as I can take
You don't want any easy ones. I think not. Thank you, Mr. Bendron.
I'm deeply obliged,
so
lady. Very grateful. And my lords.
My learned friend put a great deal of weight on page 33 of the record, ultimately conceding that it was not put to any of the appellant's witnesses. Indeed, it was not put to any of the appellant's witnesses that prior to the remediation works being carried out, that there was liveliness, bubbling, that you could see oil coming out of the ground, or gases could be smelt coming out of the well or out of the ground. The only relevant evidence was that there were trickles of oil coming out of the sands to the west of the well that were gathered into the pit and regularly, every 2 to 4 weeks, depending on the season, removed. In the rainy season, the small quantities involved would be seen to be floating on top of the water. In the dry season, what was there would have been whatever had not evaporated over the course of the couple of weeks or month since it was last emptied. And the references in the evidence, so Mr. Sankersing in cross-examination 1140, first witness statement of Mr. Cadogan, paragraph 5 at page 300, and cross-examination of Mr. Julian, I'm so sorry, Mr. Julian in his witness statement, paragraphs 11, 13, and 14 at 624 and 624 and 1624 and 1625. Mr. Archie producing a 1927 log does indeed demonstrate that there's gas. There was evidence from him that typically in a reservoir you get 99% oil and 1% gas. The gas is good gas, if I may put it that way, because it helps bring the oil to the surface. And when that gas is no longer helping in that process, it all has to be pumped up. Its presence is entirely what you expect. It does not help my learned friend, nor does it, in particular, the gas that was there in 1927 does not demonstrate that any gas that might have escaped in that area through the sands came from that particular reservoir as opposed to some other. The learned judge found, and there was plenty of evidence from the appellant's witnesses upon which that finding could be based was that no oil at all and no gas escaped from the well prior to the remediation works. The only escape was of oil into the pit, as I have described. The reasons for doing the work were explained as avoiding a fire risk, and the learned friend makes a point that they seem to have spent a lot of money. The fire risk was a risk that was of concern in the dry season. That's apparent from paragraph 8 of Mr. Cadogan's statement at page 300. If a fire would have broken out, perhaps naturally, perhaps because of all the rubbish that was thrown there, or for some other reason, and it spread because of a pit, not full of oil, but a pit containing some oil, that could well have resulted in very serious repercussions so far as the appellant is concerned. There would have been the risk of loss of life, certainly the risk of damage to property. We know that the respondents live only 40 feet away, and there are others that live in close proximity. And it was not challenged in the cross-examination of Mr. Cadogan, and Mr. Julian also dealt with this, that their motive had nothing to do with fire risk from the small quantity of oil in the pit, but because there was gas permanently escaping into the atmosphere through the sands, and that's what they really had to deal with. My learned friend wanted to put a full, in the sentence that ends VOC gases like hydrogen sulfide and sulfur dioxide. My learned friend wants to put a full stop, but indeed to cross out the words gases like hydrogen sulfide and sulfur dioxide. In my respectful submission, that is what Justice of Appeal Smith meant. And it ties in with his theory that there had been a seepage of gases or low level of VOCs in the area, which he deals with at paragraph 38 of his judgment, page 2533. He may have completely misunderstood what VOC gases were. The minority judgment makes the point powerfully that VOCs, these other gases, were simply not explored in the evidence, and it would be quite wrong to found a majority judgment of the Court of Appeal based on a theory that had not been explored over trial that ran for very many days. It was open to the judge, because this point was made to him, to come to a view as to whether Professor C. Mungall's evidence was to be discounted or ignored because he had not seen the patients. He took the view that he should rely on that evidence, and indeed he was perfectly entitled to, because there was simply no need. Seeing the patient was not going to help him form a judgment about the linkage between exposure to hydrocarbon and the home or perhaps a work environment. Had he visited the site, as indeed if Dr. Trockman or Dr. Bagum Khan would have visited the home of their patients, the judge's unappealed finding is that such a visit after April 2006 would have revealed a clean environment without a hint of gas. They'd have gained nothing by such a visit. It's very common for medical experts to give evidence in a case where a claim is brought by the personal representatives of someone who died as a result of medical negligence, or perhaps died in a factory accident. You don't need to see the patient in order to be able to give helpful expert evidence about the causes or the contributions to the causes of the death of the patient in question. The learned friend refers to the fact that Dr. Trotman saw her patients several times. Indeed, she did. She needed to, they were her patients. She was treating them. She had to diagnose what was wrong with them and see if there was any kind of drug or any advice she could give that would either cure or alleviate their conditions. The learned friend ultimately couldn't get any further than pointing to page 500 to the book produced by Dr. Bagum Khan. I say nothing more about that, but I do stress the fact that she, as an expert who was there to help the court, if making an assertion that there is a link between exposure to hydrocarbon gas and the development of either or both of the respondents' diseases, it was for her in her report. And if she forgot to do it first time round, it was for her to do it was for her in her supplemental report to go and draw attention to the studies or the personal experience she had as a clinician that made that link. She did neither. In cross-examination, she referred vaguely to texts, and ultimately she brought along a book, a single one, and I need to say no more about the table on it. And the judge was entitled to discount that evidence and to put far more weight on the fact that Professor C. Mungle had carried out a search, had narrowed it down to 230 relevant studies, and found only one that might have had the most marginal relevance, namely the New Zealand experiment on rabbits, from which he did not draw a conclusion of any connection, and nor was any put to him, it was not suggested to him in cross-examination that the lungs of a rabbit work exactly the same way as the lungs of a human, and therefore he should have made the connection. And again, it was Professor C. Mungle who told the court about the study that he had discovered about the effect of exposure to asphalt on children, not adults, children. Apparently, this study showed there was a distinction between the two. But what he was not asked about, and of which there is no evidence, is what were the toxic agents in the asphalt that might have had some effect on the health on children, but for some reason would not have had that effect on adults. And therefore the judge had to do the best he can. The judge did not say there is absolutely no possible link between hydrocarbon exposure and the development by the respondents of their respective lung diseases. He said the jury was out. This is not a case where the connection, my learned friend used the phrase about where everybody knows the answer. Well, smoking being bad for your lungs, everybody knows that answer. They might not have known it 50 years ago, but they certainly know it now. The jury is out is another way of saying that on the balance of probabilities, the respondents have failed to prove the linkage. The burden was on them. They failed to do it. Their own experts were not able to do it, and they were unable, but in the cross-examination of the two doctors who were called by the appellants to prove the linkage. And it wouldn't help them in any event, because they would have to prove that linkage either from the clinical experience of one or other of the medical experts, or from scientific studies that the medical experts were able to bring to the court's attention. Finally, so far as the law is concerned, we have not suggested that the Bonington line of cases, by which I meant up to and including Fairchild, that they are not part of the law of Trinidad and Tobago. It's quite clear from minority judgments discussion of the authorities that he treated them as such, and your lordships similarly can and should, but we say you don't get there because there is simply not the evidential basis for applying that line of authority. Unless there's some other point I can assist my lady and my lords, those are our submissions in reply.
It appears not, Mr. Taylor. Thank you very much. Well, thank you to everybody, those who've contributed both orally and in writing to the submissions that we have heard. We found them extremely interesting, and we will now go away and take time to consider our judgments. Court's now adjourned.